So before we go back on the record, there's been a request to change the order of presentations for the final segment, the public need benefit segment. There's a proposal to change the order so that NPGA would go first, and then NYPGA and PGAN would go second. I set up this order somewhat arbitrarily anyway, but is there any objection to that switch?
Your Honor, there's no objection to that switch, but we have reconsidered our objection to having the applicant have time to present during that portion of the conference. And in fact, we are questioning the propriety of having a discussion of public need and benefit at all, given that pursuant to SECRA, consideration of public need and benefit is
just a moment. Maybe we need to go on the record for this.
Oh, we're not on the record?
No, not yet.
Oh, okay.
I thought this was just going to be a discussion about scheduling. I didn't realize.
No, we better go on the record for this. My apologies.
And I guess before we go on the record, I had scheduled in a half an hour for lunch. Does everybody here want to try to just conclude this and have lunch after this is all over, rather than taking a break? Because I guess half an hour is probably not really realistic anyway, right around here. Yeah. Unless you all want to go over to Friendly's, right? and I asked the reporter if that would be okay, and she said that would be okay, and I think she's the main determiner of that particular issue. So. All right, so let's plan on then try to just conclude this morning, and we'll take breaks between issues as we've been doing, so we don't kill anybody. Yeah.
Just I checked into the hotel here, and we could just break for 10 minutes before lunch time.
Okay. All right.
Take 10 minutes.
All right. All right. So let's go back on the record then. And we have an objection from the Seneca Lakes communities concerning the presentation on public need and benefits by applicant on behalf of the United Steelworkers.
Yes, Your Honor. Well, first, our understanding was that the applicant had suggested that they would be speaking not only to the petition of the United Steelworkers, but also generally to the subject matter of that session, which is the project's public need and benefit. And we have reconsidered our lack of objection to them taking that opportunity, and indeed have questions about the propriety of having a discussion of public need and benefit at all at the issues conference. It is our position that a consideration of public need and benefit under SECRA is primarily, if not exclusively, for the purpose of determining the appropriate range of alternatives to the proposed action. We've just had a lengthy and spirited exchange on the subject of alternatives. It is clear on the basis of that discussion that there are at minimum questions of fact about the adequacy of the range of alternatives that was suggested and the extent to which that adequacy or inadequacy relates to public purpose or the public need and benefit of the project. And given that, we would submit that it's more appropriate for that issue to be addressed in briefing in connection with the alternatives. At a minimum, we believe it's inappropriate for the proposed amici and certainly for the applicant to be able to get up and give essentially uncontested commentary on public need and benefit without putting it in the context of the alternatives analysis.
All right, well just procedurally though, the presentation, the issues conference was to allow the petitioners to defend their petitions against objections that they failed to raise substantive significant issues. All three of these, or four of these petitioners, albeit they're seeking amicus status, have submitted petitions to appear as amicus. And staff had indicated in their letter that they considered that none of the petitioners had raised substantive significant issues. So based on that, I scheduled it in so they could defend their petition, just like every other petitioner has, including some other amicus party petitioners like the Finger Lakes Wine Business Coalition and the two legislators. So
I guess I would just say three quick things in response to that.
And granted, I mean, as you're probably aware from my earlier questioning, one of my questions I have for amicus is if they're proposing to present new information, that's not something that amicus generally does in our hearings. They're only in order to make argument on legal issues. So that'd be
Right.
part of my reason for wanting to hear from them, so they can explain to me what their position is. But
Right. That's fair, Your Honor. That would have been one point. My only other 2 points, and it is appropriate, obviously, for the department to have an opportunity to be heard on this question. My only other 2 points would be that we would renew, or we would now object to the petitioner having opportunity to present in that context. Certainly
Petitioner.
anything, I'm sorry, the applicant. Certainly anything beyond representing what's in the United Steelworkers petition, although I question the propriety of the applicant doing that, given that they are not, these attorneys do not, as far as I know, represent that proposed amicus party. And I would also ask that it be noted that we do believe that this is a conversation that is inextricably linked to the alternatives discussion for your consideration.
well, but isn't public need and benefit? Aren't those to be considered in any balancing at the end of the process? If it's concluded they're unmitigated environmental impacts, then SECRA would require the decision maker to balance those impacts against the socioeconomic benefits of the project. And my understanding was that that's where public need and benefit went to, was that balancing.
With respect, Your Honor, SECRA requires the lead agency to select the alternative with the fewest unmitigated significant adverse environmental impacts.
Right.
That's where public need and benefit comes in. It comes in the definition of the appropriate range of alternatives and the selection of the alternative with the fewest unmitigated significant adverse impacts. It's not a balancing test. SECRA is very clear in terms of what the finding statement is required to reflect.
It's not about, it sounds like we're getting into a debate about, should I schedule in some time for you? Would that satisfy you? Can I give you some time to be heard on the issue when we get there?
No, Your Honor, we would reserve our right to respond in briefing.
All right.
Your Honor, department staff. The department staff isn't challenging the amicus position of the union and guest association. We just wanted to make that clear. The department staff had just said that they didn't believe it was a substantive and significant issue as to need. Ms. Sindel is completely wrong in her legal interpretation of SECRA. In fact,
Well, let's not get into a discussion about that, but so there is no objection to these petitions for party status by the potential amici here.
Department objection?
Well, the reason I scheduled them for argument was because I understood the department objected to all petitions. You didn't distinguish in your letter. You simply said no party has raised any substantive significant issues. So I understood that to mean that you were objecting to all the petitions. So if you have no objection to these petitions for party status, and I heard no other objections to their petitions for amicus status, then we can cancel this portion of the proceeding.
We could have maybe been more nuanced.
Perhaps.
Yeah. So we do not object to their standing, but we do say that there are no substitute. Well, yeah.
Would you like to come up?
They haven't raised a substantive significant issue.
Yes.
So,
Well, if I could try to clarify just for a second. In our practice, when the amicus come in, they're actually briefing on the legal and policy issues that an ALJ decides is adjudicable. So if you find there are no adjudicable issues, there's no need for further briefing. So it was in that context that we were saying, we don't actually think there's a need for adjudication on any of the issues raised by the petition for full party status and thereby by implication. We didn't really need to hear it, but we didn't necessarily object to the environmental interest or the legal and policy issues that might have been raised by the petitions in and of themselves. But I think we were prepared to talk about public need and benefit because it is a component of what the department needs to consider. So that's why we didn't
but as an
intend.
amicus, they wouldn't be proposing those issues for adjudication. They would simply be
Right.
commenting on them through the process.
That's correct.
All right. So is it fair to say then there's really no objection to these petitioners that we need to hear argument about whether or not we should reject their petitions or not for party status?
Right. I mean, to these, as far as party status, but we were prepared to say that the specific legal and policy issues that they raised were a problem. It's just that, at least for the appropriate gas associations. but we assumed you scheduled this because there is a component of the SJS or the DEIS that actually talks about project.
Right, but the purpose of this is not simply to go through every issue
No,
that was
of course
covered by
not.
the EIS.
No.
The purpose of this issue is to determine whether or not to grant party status to
Correct.
petitioners based on whether or not they raise substantially given issue. So that's why we're here. So I don't really want to go into issues that aren't being raised by the parties as basis for their petition. So if there's no objection, then I don't see why we should even need to discuss it at this point. I assume I'm going to hear differently from Mr. Alessi.
Yes, Your Honor. I would like to start with the uniform procedures and why they exist. They exist to protect the applicant.
Okay.
The applicant has rights.
Do you object to these parties being parties to the proceeding?
I do not. I object to the fact that they have traveled, one person across the country, another here based upon a notice, based upon a schedule that came out, that came here to speak about the public need and benefit. The regulations, they came here to advocate why they are supporting the issues and the position of the applicant in this hearing. And one of the issues, and this is why it's getting more and more remarkable, that one of the issues they talk about, the union, the one we were going to speak on behalf of, talks about the public benefit to this applicant, the public benefits of this applicant, and they want to be part of the record. This is no different than any other amici that came in here, right? So why should they not have their opportunity to advocate their amicus petition different than anybody else, one, and two, they're speaking to issues that are germane. We just heard discussion of the no action alternative, and this is the main point. The no action alternative that Gasfrey Seneca quotes, they say the no action alternative discussion should evaluate the adverse or beneficial site changes that are likely to occur in the reasonable foreseeable future. I quoted the seeker handbook for the source that talks about satisfying the no action alternative can be simply and adequately addressed by identifying the direct financial effects of not undertaking the action. That's what the union petition amicus does. It says, if you don't go forward with these actions, these are the effects that happen. So it is directly relevant to the issues that we're discussing, and amici should be able to come in and discuss public need and benefit because it relates to others, just as we've been going for 2 days, amicus coming in and talking about other issues that relate to their interest. I would solve this issue that was raised very easily and would agree not to address any issue that is not in the petition of the union. That'll take care of that issue. I think that the amici have all spoken to matters. We've not objected to Ms. Treichler several times coming up and speaking about issues that are not in her petition. And we didn't object, but now we've got to be constrained, and the union's got to be constrained about what they can speak to. So we're trying to be reasonable.
Well, I don't
here,
think
Your
we're
Honor.
talking about constraining them. I mean, they'd certainly be able to be heard in the briefing, which a amicus would be entitled to do. And there's apparently no objection to this. But hold on, let me ask: do you wish to be heard here today, or will being heard in briefing be sufficient for you?
Judge, we would like a brief opportunity to be heard. I mean, we have traveled here. There are some issues that were raised earlier. Whether you're putting it in the bucket of alternatives or whether you're putting it in the bucket of public need,
All right.
I think that there are some issues that we need to address,
Okay.
especially if we're not going to be addressed.
All right, all
Your
right,
Honor, we'd like to be heard here and in brief.
all right. And Mr. Leslie, you would limit your comments to basically, can you represent United Steelworkers? Or have they authorized you to represent them?
Your Honor, the answer is no. They transferred their time just like everybody else. When somebody else came up to speak to an issue,
But I didn't schedule any time for you because wasn't aware that you had any objection to these petitions.
Judge, I raised this issue yesterday, and I tried to get it addressed yesterday, and Your Honor said, let's take care of it tomorrow. I tried to address it yesterday because I thought it was the right thing to do for a scheduling purpose. Once we knew about it, as soon as Mr. Bacon told me that Ms. Shaw was not going to be able to make it, I raised it. You said tomorrow. Okay.
Okay. well, now it's tomorrow, so.
So that was tomorrow, so I don't understand.
All right, I don't want to make a mountain out of a molehill possible here. Can I give the other petitioners time to respond?
Your Honor, we were given no notice whatsoever that we would be required to respond on this issue. And Mr. Alessi just got up and made a passionate argument about how there is no issue in play on alternatives. Can't have it both ways. If there's no issue involved in alternatives, then absolutely nobody has, and we have not raised public need as a separate issue. It's very different in the situation with blind business owners and the Blind Business Coalition and the legislators, because they are asking to do amicus briefs on issues that petitioners have raised. Now, there is no petitioner that has raised that issue, and there's now no objection. They're trying to come in on an issue that's not in play. So, I'm sorry that they came all this way for no good reason. My expert is sitting here for a full day for no good reason also, because we didn't get the schedule in time. That's the way things happen. But under your own rules and under your own understanding of what amicus does, there's nothing in play here on which they can present the argument.
Well, it's their own petition.
What? Pardon?
It's their own petition. I've
But
allowed the
no-
amicus to be heard on their own petitions.
Correct, but there's nobody objecting to their petition. So why is there argument?
Yeah, their petitions speak for themselves, Your Honor. Their petitions are part of the record. If they're given the ability to brief, that will be part of the record. I share Ms. Goldberg's regrets that you traveled a long distance, but frankly, the department wasn't clear about the extent to which it was or was not opposing to petitions. And there's no reason that they should have an opportunity for an uncontested presentation on what is in their materials that Your Honor has and that is not being contested. And I just want to reiterate that without authority to represent the United Steelworkers, and given that their position is fully presented in their materials, there is no reason for applicant to have time to present on this issue.
You're under the regulations.
Here was Magliani, she stood up first.
I think we probably spent more time talking about whether they should
I know.
speak than it actually would have probably taken them to speak. And I just think if we're here with the opportunity, everyone had the opportunity to present their particular side of the issue. I think in the interest of fairness, people have been able to see time to each other, and nobody's objected to that because I think everybody has had an opportunity to be heard. We heard from the legislators yesterday. They are also a petition for amicus says. We heard from the Finger Lakes Blind Business Coalition. They had an opportunity to raise their arguments about why they're opposing the project. I think in the interest of fairness, the people that showed up, submitted a petition and had the opportunity, should be given the opportunity to be heard. I mean, we're the DEC, we like to be criticized by everybody, so it might be nice to actually, give everybody that opportunity to come in and state why they actually submitted a petition and why they're here, and why they should be able to contribute to the record. I think it's a fair thing to.
And how about specifically about the United Steelworkers?
The Department of Staff doesn't have any objection to it. As I said, people are able to see time to each other, whether or not they even raise issues of their own in petitions. I mean, to give somebody 3 minutes of your time and 4 minutes of your time, nobody objected, and we certainly could have. But certainly when those parties didn't raise issues in that specific area. So I think in the interest of fairness, I think the Department of Staff doesn't have objection to having everybody give an opportunity to talk.
Thank you.
Your Honor, if I might be addressed for a moment. Just this morning, we've heard argument from gas-free Seneca, and I think from Seneca communities, about the need for public process, public input. Yet when it comes to our viewpoints, they object. I find it a tad inconsistent.
Well, I think I'm certainly going to allow both of you to appear on behalf of your petitions. I guess the one remaining question is about the United Steelworkers. So, and would you limit? Did I understand you were going to limit your presentation to defending the United Steelworkers petition?
Your Honor, in order to resolve this issue, yes, I think it's unfortunate that someone who comes in to support a petition that gets snowed in and can't make it in Buffalo, that the union, the people who have jobs at issue here, are basically got to fight for, after we've given the courtesy to everybody, as Ms. Magliani said, I think it's quite unfortunate. We've got to come in here to fight to do that, but if that's what it takes in order to them to have a voice and to follow the regs that say that amicus can come in and support. That's what the regs say, can come in and support. They don't have to raise a substantive and significant issue. They can come in and support. So when Ms. Goldberg says there's nothing in place, she is completely wrong on the law. Amicus can come in and support the applicant. And that's why I was referring to the regs about, protecting the applicant. That reg is in there for support for a reason, so that the applicant, so there's some measure to these processes, because otherwise you would just have issues conference for opposition, substantive and significant. You have that in the reg for support, so there's a voice that can come in. Why would there be no voice for people in support, in the same voice open to public, to the media, etc., so their voice can be completely heard? So if that's what it takes, Your Honor, to give the union workers a voice, a mere voice in this 2 days, I would do that. I prefer not to, but if that is what I need to do, I will do so.
Well, that was the purpose of putting them on, so they can defend their petition. So if you limit your presentation to defending their petition, then I think that'd be appropriate. Now, again, I'll offer to the other petitioners time to rebut if you wish to take it.
Your Honor, we're not prepared to rebut it. And as I said, we would reserve the right to do so
In briefing.
through briefing.
All right.
I don't want to belabor this any further. I want to be very clear. It is not our position, the position of our clients, that anybody should be silenced here. It is our position that when there are uncontested petitions, as there are here, hearing on them is not an appropriate use of judicial resources during an issues conference. We are not trying to silence anybody here.
All right, thank you. Ms. Goldberg, did you have anything further on this?
Well, we join in what Ms. Seeley just said. Nobody here is trying to silence the public. We are trying to adhere to rules, and there are no objections to these petitions. We're just giving them an additional opportunity to speak that other folks do not.
And then you would decline at this point to offer any rebuttal? It'll be done in
Yes, sir,
petitioning?
I think it would be more appropriate to confine it.
Briefing, okay.
Your Honor, if I may. Since we're discussing party status, we believe it's become clear from the proceedings here that we are in a unique position to provide new information. When we filed our amicus brief, there was no draft comprehensive emergency plan for the county. And now, the 2008 plan, which is outdated, has been distributed as part of the record. And we would ask for permission to modify our petition for party status to apply for full party status, because we believe we have important information to bring to the
I think we'll have to leave this for after the issues conference. If you're going to be making a petition for full party status, then they'll have to meet some standards under our regulations. So I think we can handle that in an orderly fashion post-issues conference.
But we would be able to.
You can make an application for full party status. It'd be a late filed petition for full party status, and there are standards in our regulations that govern that. You're welcome.
Your Honor, if I could just be heard very briefly.
Sure.
Mr. Alessi took the position that an amicus does not need to have an issue, that rather they can speak in support or opposition. Certainly, if that's the standard to be applied, we would welcome it, but it's our understanding in our petition for amicus status, and I believe in the questioning from Your Honor, that we have been bound as an amicus to be tied to particular issues that you determine are adjudicable issues. If in fact the standard is whether or not we support or oppose the application, we would certainly like our petition to be considered in that light and be given the opportunity to speak solely on the basis of opposition to the application.
I'm sorry, I'm not quite sure I understood what you were getting at.
During the presentation, Mr. Alessi, in support of allowing the amicus to speak today, indicated that it's appropriate for an amicus to speak solely in support. I wasn't clear what he was speaking to, since Ms. Goldberg had raised the issue, and
No, I think what he was saying is that a party can come in both in opposition and support of a project. Our regs do require that even an amicus has to speak to a substantive significant issue.
And I believe that was the point that Ms. Goldberg was making, is that we have not identified a separate issue for this amicus. And I'm not going to speak to whether or not this amicus should be permitted or not. We would just like to be held to the same standards as an amicus in terms of our position on the various issues that we have raised.
Okay, yes. Certainly.
Your Honor, if I could speak to that. The regs are not entirely clear, but this has been discussed endlessly. If you read the regs, a certain section of it literally for amicus, it would mean that a person, because there's a part of the reg that says for amicus you have to address a substantive, have an environmental interest, and you have to address a substantive and significant issue. So the question had come up years ago, well, what if someone comes in to support a project? And when Your Honor is looking, you can look for this section that addresses municipalities, for example, and there's some others. What if someone wants to come in and support a project in an issues conference? Wouldn't it be crazy if someone, to be able to come in as amicus in an issues conference, had to...
Can I cut
Yeah.
to the chase real quick here? 6 NYCRR 624.5B1B. One of the required contents of a petition for party status is to identify precise grounds for opposition or support. So I think our regs do make it clear that parties can seek party status in our proceedings, both in opposition to a project and in support of a project. So if that answers the question.
It actually supports what I was saying. I don't think it addresses Ms. Tour's point, which is she wants the same standard, which she basically said we don't want to have to show a substantive and significant issue if the petitioner in support doesn't have to. And my point is an amicus in support of a project is not going to come in and say that the project is defective, that it doesn't meet a standard. That's just not what happens. So the provision you just read has always been interpreted to say that if you're going to come in opposition as amicus, you have to address a substantive significant. If you're going to come in support, you don't, because you're supporting the project, you're not going to come in. So that's what I was addressing with Ms. Tour's point. She was saying, Mr. Alessi created a standard, I want to live by that standard, all I got to do is come in and oppose or support, and I don't want to have to be held to a substantive significant.
So perhaps this was my mistake. I based the schedule, this was purely ministerial, I wasn't trying to make determinations on the merits of anybody's petitions. I simply put out the schedule based on my understanding of who I believe were being opposed by somebody in the proceeding here. Clearly, with respect to the party status petitioners, other than the gas associations of the United Steelworkers, the applicant and staff were clear that they opposed their petition. So I scheduled argument by the petitioners and in response by staff and the applicant. I understood that there was a objection to the gas amicus as to whether or not they raised some significant issue. I understood to be the case from staff. So perhaps I should have scheduled in time for everyone else. That's my mistake. I'm offering to allow that, but what I'm hearing is that the party status petitioners who would oppose these believe, because they're not prepared, because my mistake in terms of scheduling, are not prepared to speak to their petitions, and it'd be better to do it through briefing.
Your Honor, I don't believe it's your mistake, honestly. We had a very clear statement that they did not object. They're saying now they do not object. The rules say there has to be in play a substantive and significant impact, and there's a perfectly good explanation for the rule that you pointed out, and that is that sometimes there are issues conferences when the department denies a permit. If the department denies a permit and the applicant asks for an issues conference and gets one, then someone will come in support, and they have to identify a significant and substantive issue. And there may be nobody on the other side except the department. That is one situation. In this particular situation, the department has put out a draft, and you have just the mirror image of that. There's no reason in the world why an amicus should be permitted in here where there's no underlying substantive and significant impact.
So is it your position they don't have some significant issue?
Nobody has put one in play. We have not raised purpose and need as a substantive and significant issue. We have adopted.
But they're proposing it, so is it your position that they don't have a substantive issue that they should be heard on?
No, they have to identify as amicus
Right.
Right? There has to be a petitioner who
Right.
has raised the subject of the significant issue, and they will speak to
And I
them.
believe that's what they've done. They filed a petition saying that, in essence, that the analysis of public need and benefit isn't sufficient, and they want to supplement it as amici. Now, whether or not they can actually do that as amici is another question, and that was what I was going to question them about, but they have proposed an issue for adjudication, and they've indicated, what their interest is, and they want to be heard on it.
And what they've said that they're going to do, and perhaps you'll just question on that, and we'll be done with it, but is talk about the effect, which is not,
Okay, but that getting the substance of their petition, so it sounds to me like there's an objection to these petitioners, in which case I think they should be allowed to be heard.
Your Honor, that's exactly right, and again, I'll just state, we would like to have the union have a voice at this issues conference like everyone else had on its petition. It's that
All
simple.
right, thank you. I'll allow the petitioners to be heard on the petition. I understand that the responses to those, that presentation will be done in briefing. Again, I apologize for the schedule, the way it is, if it was my error. And I understand the objections of gas-free Seneca. All right, thank you. So don't cancel your plane ticket. All right, so we're on to the issue of cumulative impacts, and starting with gas-free Seneca.
Thank you, Your Honor. If I may, I'd like to reserve whatever time I don't use for rebuttal. Thank you. Under SECRA, the draft EIS should analyze cumulative impacts where applicable and where the impacts have the potential to be significant. Here, in the draft, there is no such analysis of any kind of cumulative impacts whatsoever. Despite the fact that the Arlington Gas Storage Facility is on the same property as the LPG, the proposed LPG storage facility, is owned by the same parent company, and involves the same type of activity, which is the storage of hydrocarbons in salt caverns. The Arlington facility there's a portion of it that is existing, and then there's a portion of it that is planned and has been approved by FERC. These two facilities will have an important and fairly obvious potential cumulative impact that have not been assessed in the draft supplemental environmental impact statement or elsewhere. The SECRA handbook instructs that a cumulative impact analysis should be done when the impact, and I quote, "The impacts of related or unrelated actions may be incrementally significant and the impacts themselves are related," end quote. Or when the two actions are in close enough proximity to affect the same resources. And that's at page 84. Clearly, this is what we have here. Two next-door facilities controlled by the same entity engaged in the very same industrial endeavors, or very similar industrial endeavors, that will impact the same community and the same resources. The applicant, however, attempts to justify the omission of the cumulative impacts analysis by, again, claiming that it was not required by the scoping analysis. This, as we have discussed at length today, is not a sufficient explanation that will render a document acceptable under SECRA. You cannot simply say that it wasn't required in the scoping outline, and therefore this analysis is adequate under SECRA. I should point out also that as part of the comments that were raised on the scoping analysis, that the cumulative impacts were raised by at least one commentator. And again, to the extent that Mr. Leslie wishes to go and look through the comments, as he apparently likes to do, I would caution searching for specific buzzwords that lawyers use when assuming that the public hasn't raised a particular issue, especially when we're talking about cumulative impacts. As Your Honor also recognized yesterday when discussing community character, the fact that an issue was not raised in the scoping process does not mean that the issue isn't worthy of further inquiry at a later date, such as at an issues conference and an adjudicatory hearing. In addition, as Mr. Croyce discussed earlier today, there's very obvious precedent in St. Lawrence Cement that expressly holds that the failure to include an item in the scoping outline does not preclude consideration of that issue as part of a 624 issues conference. The applicant also attempts to say that the cumulative impacts analysis is not required under SECRA. However, in Save the Pine Bush, the Court of Appeals held that there are certain circumstances in which cumulative impacts must be analyzed. Specifically, the court found that when you have related projects, a cumulative impacts assessment is required. Chinese staff also stands for the same proposition. As I mentioned, the Arlington and Finger Lakes LPG storage facilities certainly are related. The facilities, as I said before, are on the same property. U.S. Salts are owned by the same parent company and are part of the same overall plan by Crestwood to create a natural gas storage hub in the Northeast, or a natural gas liquid storage hub, including both natural gas and LPG. Moreover, it's fairly obvious that the combined impacts of these two facilities could be significant. The caverns that both facilities intend to use are in very close proximity to one another, and given the hazardous nature of the products to be stored therein and the associated risk, these two projects pose a potential combined safety risk to the community that has not been assessed. The creeping industrialization represented by both facilities also poses a risk to the quality of the community character, which was discussed at length yesterday. Also, given the timing of the project and the fact that the Arlington project, though approved by FERC, but had not yet constructed, the expansion rather, there is a potential for the construction of both facilities to occur simultaneously. This has not been ruled out, and so as a result, there is a potential for combined construction impacts that would potentially result in additional noise, traffic, and other potential impacts. I'd like to note that in considering this in Arlington storage facility, FERC did, under NEPA, analyze cumulative impacts in its EA under docket number CP13-83. But that analysis was limited to groundwater, surface water, and air quality impacts. Nowhere did FERC analyze safety or community character. Also, FERC assumed that there would not be a common construction schedule, and their finding in their final order that the cumulative impacts of both projects together would be insignificant was predicated on the assumption that there would be adequate mitigation measures imposed by the New York DEC on the LPG storage facility. And as we had extensive discussion yesterday, that issue is in very significant dispute. The failure to consider cumulative impacts, therefore, renders the DSEIS insufficient, and it warrants either, as we've discussed in the case of alternatives, extensive discussion as part of an adjudicatory hearing, at which point the public is made very aware of the fact that members of the public are able to submit additional comments on whatever analysis is released, or that it warrants the publication of another draft of the SEIS, and we would ask Your Honor to order one or the other, or both. And I'd like to reserve the remainder of my time. Thank you.
All right, Finger Lakes LPG.
Thank you, Your Honor. I am glad that Ms. Naismith corrected an oral argument for a significant misstatement in the brief, which is, in a brief, she said cumulative impacts must be analyzed, and today she appropriately noted that the regs say that they could be analyzed only where applicable and appropriate. That is the correct standard, as we pointed out to them in our brief. Here's my question with regard to cumulative impacts, Your Honor. Where's the offer of proof? There is no offer of proof. They put in their brief their legal argument that there should be a cumulative impact analysis. Where is there any offer of proof as to what impacts they consider significant? What impacts, if not significant, when combined together, would be a cumulative impact? That's what the issues conference is for. They can't come in a brief and just say, you should analyze cumulative impact. The reason why this is important, and you'll hear more about this later, is there were cumulative impacts analyzed. So
Was the Arlington facility analyzed in the context of cumulative impacts?
Your Honor, I'm going to let...
Isn't that the offer of proof? They said next door is the Arlington facility, which is a similar facility with a similar impact on the community and on the resource. Was it analyzed? Was the Arlington facility analyzed in the cumulative impact analysis?
The answer is yes, but also, Your Honor, I would like to note that we purchased that facility in July of 2011. So things are kind of hard that when we start the movie here at the Issues Conference, like many of the other issues, that, I think we have to understand a little bit about where we are in the process and take a look at what the real on-the-ground situation was way back in 2009 when we put this in.
But doesn't secret require that we consider reasonably foreseeable cumulative impacts, right?
Not require, only where applicable and where the impacts are significant. So that is my question on the offer of proof. You can't just simply say you have another facility and you have this facility, you should look at cumulative impacts. You only look at cumulative impacts where you've got two significant impacts, they combine, or you have impact, pick your impact area. Neither one are significant in and of themselves, but when you combine them, they become significant. There's no offer of proof about that analysis at all in their petition. Where is it? What are they talking about? Traffic, community character. What is the issue that accumulates? What is the impact that accumulates to make it significant between these two projects? That's the failure of their offer of proof. It can't be a mere legal argument. And in every case that they cited, the record in Save the Pine Bush and the record in others, the parties there put in and identified and made offers of proof. And it was actually not offers of proof in Save the Pine Bush. It was, it might have been an offer of proof, but they put in what the impact was. So again, Your Honor, we have to be on notice as to what we're shooting at here and not at this particular time. So to me, Your Honor, that is a fatal flaw in the whole cumulative impact analysis. And I think another barometer of that is no other party has brought up cumulative impacts. And they can speak to why not, but it may be because there are none, and it may be because the offer of proof would have to address it. But this is the only entity that has raised it, and they failed in their offer of proof. With regard to the mention of FERC, that is not under seeker, that is under NEPA. The requirements for cumulative impacts are completely different. Ms. Goldberg and I had a very robust discussion about that in the Second Circuit 2 years ago about cumulative impacts and NEPA requirements. They are different, so to cite to NEPA as for anything is inapposite with regard to this matter. So also you heard talking about another facility. I just want to remind for the record that we've got gas and we've got liquid, so we have different situations with regard to certain aspects.
Let me ask you quickly about NEPA. So is the federal standards more protective than the state?
Your Honor, it's not that they're necessarily more protective. The NEPA with regard to cumulative impacts is pretty similar to what New York State has, but the case law does have some differences with regard to cumulative impacts. And it's not a matter of is it more protective, it's just that the requirements are different. And in NEPA, the seeker handbook is very clear, and it interprets and reviews case law. It's when you have a common resource. That is the whole point of cumulative impacts. And again, the offer of proof, had it been done properly, would have said these are the impacts and this is the common resource. Even in their petition that doesn't have an offer of proof, they don't even identify the common resource even in their legal argument. So that's another failure of the cumulative impact analysis. So
the state standard has you look at a common resource.
Yes.
What's NEPA have you look at?
Your Honor.
How is it different? What's significant about the federal standard that's different here?
Your Honor, I don't want to, I'm not prepared to speak to the precise differences of NEPA. I didn't come here prepared just to speak to that other than to say it's a different statute and the case law has been interpreted differently, but I'd have to go back and look. I want to give you an accurate answer. So, Your Honor, the point on cumulative impacts is that there's been no offer of proof whatsoever to identify even what these impacts are. What's the area? There's no identification, no offer of proof, and no statement about a common resource. No statement even in their document. And therefore, this claim that cumulative impacts is a shortcoming is completely incorrect. It is an abject failure in terms of law and in terms of offer of proof. And with regard to the matter, I'm going to let the department speak with regard to the record. We'll submit further items for that in briefing. I just wanted to hit the issues conference issues in terms of their failures of their offer of proof in regard to this issue. And I would add, Your Honor, that and Ms. Naismith mentioned something about what my arguments are. I'd like to have what I said just now be my arguments, not what somebody else is thinking I'm going to argue or characterizing. Thank you very much.
Oh, actually, there's somebody else's book.
Sorry?
Somebody else's book. Want anybody? All right. Okay. All set? Okay. Well, department staff agrees that there hasn't been a substantive significant issue raised on cumulative impacts. And as Mr. Leslie indicated, this was raised in Seneca's petition. They spent about a page, and they just sort of said summarily, there's no cumulative impact analysis, so it must be deficient. It is difficult because they didn't actually state what specific environmental media they were concerned about. So it was a little hard to understand how to rebut that assertion, except to say that their offer of proof was insufficient on its face. But what they did say in their petition was that DEC should have known about the Arlington facility as early as April of 2011 because there was some activity that they had talked to FERC about actually acquiring the facility. As a legal matter, I don't think it actually makes a distinction because we actually were concerned about it before that. At the time...
Well, it doesn't matter, right? The cumulative impacts now, it doesn't matter who owns the facility. If there's another facility nearby that's reasonably...
Right.
Should be taken into account, the
Right.
combination of these facilities on the environment.
Right. The secret handbook says either the projects have to be related or the impacts have to be related. Right. It's one or the other. And unfortunately, that we cite the handbook, and that's why Seneca cites the handbook, because there's actually no definition.
The impacts would be similar. You've got liquid fuel being stored. Yes. You've got trucks. You've got trains.
Well, they actually didn't say that. You're saying that, but they actually didn't say that in the petition. But that what they said today was, yeah, there's some similarities, but there's a distinction without a difference. Yeah.
There's a similar.
Oh, absolutely.
Nearby, and that should be taken into account.
And absolutely, and department met that obligation. We certainly looked at cumulative impacts, and as they pointed out in their petition, we actually asked the applicant before Energy, who was the predecessor to Crestwood, before their merger, before they actually acquired the property, we asked them, because the Finger Lakes project at that point was actually further along in the review process. We actually had a complete application in front of us. We had scoped the project. But when we had heard, and we had some initial conversations with NYSEG at the time, we actually told them that and Ms. Goldberg actually said we should have known about it in April. We actually said in March. We wanted them to go back and say, well, thank you for your reservoir suitability report and your finite element analysis, but please let us know if there's anything that changes, because now we understand that there might be, in the future, a proposal to actually to use caverns at the Arlington facility for natural gas storage. So we did actually consider that, and it's documented in the Notice of Incomplete Application. And you can see, that's correct. Right. What's cited in Seneca's petition is actually the response to our Notice of Incomplete Application.
Which one that was?
It's March, yes, it's actually document number 11, 1A11, and it's March 28, 2011. So we did. We wanted to make sure, because at that point, when we looked at the project...
And was there a response from...
Yes, there was, in April 28th of 2011. And that's what's cited in the petition. So there...
2011.
2011.
2011. do you happen to have that document number?
1A12.
1A12?
Yep,
Okay.
1A12. So in there, what they did was they confirmed, they went back and looked at their finite element analysis, because there, the principal concern of wasn't that we actually made a finding that there were any surface impacts that were going to be a concern. We were looking at cavern integrity. Is there a concern, because that was the impact that we were most concerned about. Is the pillar thickness, is the distance from those caverns sufficient so that we can make decisions about integrity at the Finger Lakes project? Because as you said, it's just because they didn't own the facility doesn't mean that we can't look at the impacts, but as a general rule, our policy is we weren't having conversations back and forth with Energy at the time, or NICEAG, because there was a process of transition, and as a general matter, we just don't like to throw a lot of issues out to parties that don't actually own the facility. We like to have direct conversations with the actual applicant.
But the focus was on cavern integrity.
The focus was certainly on cavern integrity, but now you have to understand these two projects were moving forward simultaneously. So we had an NEPA review being done by FERC. DEC was a cooperating agency in the FERC process. And when we received submissions in the Arlington project, we actually looked at that analysis and had conversations with FERC, and actually Scott Shealy, who is here today, and I spent a lot of time talking about the cumulative noise impacts and talking about how we actually reconcile a noise study that we received from the Arlington facility with the noise information that we received in the Finger Lakes facility. And Ms. Schwartz actually talked about it today. I don't know if anybody picked up on it, but we actually looked at those two projects. How are they actually going to behave together? And that's when she made a reference on the record that there's a combined decibel level of 50.3 dBA at the motel, which is on north of the facility and on the same side of the lake. So we did actually we did respond as information came in. Now the FERC application. We looked at noise.
Then how about some of these other impacts like truck traffic?
There wasn't, and construction, there wasn't going to be a combined, right, because construction, the amount of construction that had to be done in Arlington was actually very minimal. When you look at the FERC record and it lists exactly what type of construction they had to do there, we actually knew at that time that there was certain testing being done at Arlington that had already been completed. We knew, for instance, that one of the things they needed to do there was plug 2 wells. Well, that's not a concern from us. We consider plugging wells a type 2 action under SECRA. We didn't have to consider that in the purpose of making decisions about whether or not construction impacts there. The only other remaining work they had to do at Arlington was actually install the compressor unit and make some pipeline and electric connections. It was actually a very minimal amount of work. We heard today, actually, Gas Seneca said, well, we never really had an opportunity that FERC's review of cumulative impacts was really only limited to water quality impacts. Well, if you actually look at the order, it's actually paragraph 62 of the order. It states, Gas-Free Seneca also comments that the EA, the environmental assessment, ignores cumulative impacts on aesthetic, noise, and community character, focusing solely on groundwater, surface water, and air quality. So they did have an opportunity to comment on the combined impacts, because at that point, the FERC process had sort of eclipsed us in the Finger Lakes proceeding, because obviously we went on for 5 years. They were able to actually file their official application with FERC in 2013, and this was the EA that Gas-Free Seneca commented on.
Okay, I'm sorry. So what you just cited to me now was the FERC decision, or
that is the FERC decision.
Okay.
Correct. So they put their EA.
So the FERC decision considered the cumulative impacts on water quality above the Arlington and the Finger Lakes.
That's correct. And they actually said in paragraph 61 of that order as well that they actually mentioned us, and they indicated that the only possible impacts, and it says due to limited scope and impacts of the Gallery 2 project, groundwater, surface water, and cumulative air impacts were the only resources identified in the EA that could potentially be cumulatively affected. And then they go on to include how there will be actually negligible cumulative impacts on groundwater and surface water. So they did actually go through a deliberative process, and Gas-Free Seneca had an opportunity to comment, participate in that process, and raise the exact same issues about how Arlington and Finger Lakes were going to behave together. And in fact, the cumulative impact review done by FERC was actually more robust, because they said, in that petition, Gas-Free Seneca said, we want you to look at AmeriGas, we want you to look at other proposed projects in the area. And in the Arlington proceeding, they actually did a review and looked at all the other pending projects that might be filed in the town of Reading. So they did a very robust cumulative analysis. And for the purposes of the difference between the two, there's actually not a whole lot of difference between the cumulative impact review under NEPA and the cumulative impact under SECRA. The distinction is that this is instructive for us, but we nevertheless still had our own obligation under SECRA to go look at these impacts, and we did that. We looked at noise. There was nothing else in the record that suggested that any other surface impacts were going to be affected, and we concurred with this determination. So in a nutshell,
there was an opportunity to look in the FERC process at cumulative impacts of both projects as they were going to operate together. And notwithstanding that review by FERC, which we had concurred with and participated in discussions with FERC on how the noise impact analysis should be done. And after that discussion with FERC, we actually went back in the Finger Lakes proceeding and had the applicants supplement their information. Because we said, we need to reconcile the ambient values here. Let's, can you go back to your engineers or your consultants and give us more detailed information about how receptor 7 is actually going to be affected? And it was based on that decision, in part, why we imposed mitigation measures and why we want to make sure that receptor 7, that motel north of the facility, is not going to be impacted. So as a legal matter, I don't think we have to really distinguish here when this project became reasonably foreseeable, because we considered it. We not only considered it, FERC considered it, we participated in that process, and we had 2 projects moving along simultaneously. And luckily for FERC, they got a lot further along in the process, but nevertheless, the documentation in the record suggests and concludes that we did address cumulative impacts, and of course, when we publish a final SEAS, we have a robust opportunity there to respond to public comment in full. And just the note on scoping, there wasn't a reference in scoping. The comment we received in January of 2011 on cumulative impacts and scoping, the actual commenter was Ms. Lawrence, and she said, I want you to look at the cumulative impacts of building a rail yard, the brine facility, and the truck unloading area. Her comment was not look at the impacts of a facility that hadn't been proposed. It was, can you look at the impacts of all the different components of the Finger Lakes project from a visual perspective? That wasn't our interpretation, that she was suggesting that we should look at facilities that hadn't been proposed yet. So, but then again, we respond to information as it rolls along, and we did do that, and we looked at it from cavern integrity and didn't find that any other environmental media would be affected on a cumulative basis.
Okay. Thank you. So, Gas-Free Seneca, you have 9 minutes rebuttal.
I think I'll be taking that amount of time, Your Honor. I wanted to, however, address a number of points, if I may. First of all, Mr. Lessie was talking about the appropriate quotation of what is required under SECRA, and he said that the appropriate quotation was that the applicant or the department could look at cumulative impacts. It's actually should, just to be careful about our language.
Apparently the department did, so.
So, and that's my second point, Your Honor, is the department did. It's not in the draft. It's not in materials that the public has had ready access to. I would need to go back and check the materials that have been made available as a pursuant to this proceeding, but there's an awful lot of consideration that we have.
Process in which apparently the cumulative impact, analysis had been done, that was a public process, right? In fact, did you participate in it?
We did indeed, Your Honor, and I would say there are a couple of problems with focusing too heavily on the FERC process. First of all, FERC didn't have a lot of the materials in front of it that the DEC has. And the specific materials, I won't refer to them in too much detail, but there's a lot of confidential material with respect to underground cavern integrity information, specifically about the LPG storage facility, that FERC never received. We were given access to the confidential materials in that proceeding, and that there is a significant difference between the materials that we received in this proceeding versus the FERC proceeding, including things like the appendices to reservoir suitability reports. So to say that FERC was able to do the job that DEC is required to do under SECRA is not accurate given the materials that were before FERC. I would also say that we contest the fact that FERC ignored our request to do cumulative impacts analysis with respect to community character. We disagree with that decision quite vehemently and attempted to convince FERC otherwise. And as Your Honor has heard, significant argument yesterday about why community character is such an important piece of this particular project.
So FERC didn't have before a characterization of the community as being, for example, a agricultural wine country setting, but otherwise the impacts on the community, like visual, noise, traffic, those would have been before FERC, right?
Yes, and just to correct Your Honor, we did put in some comments that started to talk about the community character. We were not in a position at the time to provide as robust a set of testimony with and FERC also with respect to the analysis that, for example, Dr. Flad and Dr. Christofferson have done. That was not before FERC either. We did put in some comments to highlight the viticulture and the character of the community. It was not the same record, however, as is now before DEC and yourself.
How would the analysis been different if the community character was characterized differently by FERC with respect to cumulative impacts analysis?
Well, they would have actually conducted a cumulative impacts analysis. We would have argued that they should have conducted a cumulative impacts analysis given the creeping industrialization that is resulting from not just the Arlington facility. And I want to clarify one point as well, that although the Arlington facility was before FERC, there was an existing facility there as well. So in terms of the cumulative impacts analysis that could have been done back in 2011 prior to the expansion application going into FERC, some of that still could have been done, even though it wasn't maybe perhaps entirely clear how foreseeable the expansion project. There was an existing facility there already on the same property, engaged in the same activity, and with respect especially to the community character piece and the cavern integrity piece, it isn't simply a function of, oh, it's an existing risk and so we can ignore it. It is a function of, if you have a baseline, to what extent even an incremental addition can tip you over the significance threshold. That's something that's well established in cumulative impacts analysis.
Right,
That,
but my understanding was that they did look at the cumulative impact of the cavern, integrity, these other impacts. So I guess my question remains, what would have been different about the analysis if the community had been characterized differently?
Well, and with respect to the cavern integrity piece of it, that wouldn't have necessarily had much to do with the community character, but as I mentioned, in terms of the documents that FERC had before it, they did not have the full scope of materials. Moving on to your question about what would have been different with community character, the difference, again, would have been a more robust record in this situation, and we feel that, honestly, FERC improperly dismissed the question of community character and should have evaluated it, and didn't. They didn't really provide a whole lot of explanation other than to simply say, we don't think it's significant, but we would strongly disagree with that characterization. We would also...
I can find that characterization in the decision, right?
Yes. Yeah, they basically just say this is what we're evaluating and they move on. They don't really provide a whole lot of discussion, and they say they don't think it's significant. And again, with all the material we presented yesterday, we would strongly dispute that contention. I also just wanted to quickly discuss the question of the offer of proof. As Your Honors indicated, we think that the offer of proof here, first of all, we're raising a legal issue here in terms of the deficiencies in the draft supplemental environmental impact statement, given the standards out there where you have very clear indication that related projects must be considered to have cumulative impacts considerations under Save the Pine Bush, where there, at least, I reread the decision very quickly, and there's no discussion of what proof of significance was offered in that case. It was much more of a legal decision. There may have been more to the record than and I'm happy to look into that at a later date.
So if your theory is that basically you're just simply making the legal argument, you're not proposing to develop the record on cumulative impacts, you're simply making the legal argument that cumulative impacts was not analyzed, so therefore there's a deficiency in the EIS.
Yes, sir.
But we heard from staff that they did consider cumulative impacts. So does that mean that?
Well, I mean, I would argue that they may have considered it cumulative impacts behind the scenes, but the actual record on that is not particularly apparent, and that is the type of, whatever it is they produced as a result of considering those cumulative impacts needs to be added into the record, and again, made open to the public and made clear to the public that the public can comment on that exact issue, and perhaps at the end of that, we will have a sufficiently robust cumulative impacts analysis to satisfy the requirements under SECRA, but right now, none of that material was included in the draft supplemental EIS. There's all of the things that Ms. Maglianti mentioned are not in there.
If we were to supplement the record with the FERC decision, other materials that support the department's review of these cumulative impacts, and subjected to some further process here, would that take care of it?
It might, Your Honor. I reserve, depending on what that would actually look like, but it's possible, yes, that might actually be a robust enough cumulative impacts. At this point, I don't know, and it would depend on how that would all play out.
Well, since you're not offering factual issues with respect to it, then it would only simply be the legal questions of whether or not any subsequent supplementation of the EIS was sufficient
That
to
would be,
address.
that would be correct, Your Honor, which would
Okay.
be,
And then we'd
yeah.
either agree with you or not as to its sufficiency.
Yes.
Okay.
And unless you have further questions, I think I will
No, I
give us a few more minutes.
You have, well, actually,
Or seconds.
1 minute.
There you go. Thank you, sir.
Thank you. All right, that concludes cumulative impacts. Want to take a brief recess, or should we continue on to the identification clause? Any
There you gotta
preferences?
check out.
Oh, you guys have to go check out?
Yeah.
Should we take a recess for people to check out? How much time do you need? 15 minutes?
We're all gonna go down.
Yeah.
We're all going down
All
at
right.
the same time.
Go. For record.